Alright, looks like I'm streaming now, and it didn't put a title. I could do that later. I want to compare the conversion of appeals into writs. I find it interesting, especially since now it's about the phase that I'm in this legal process. So I originally thought that I had to do an appeal. Wasn't familiar with writs at all. I mean, people when they talk like that, it's like for TV shows when people talk about going to the higher court. They say, "I'm going to appeal this." You don't say, "I'm going to writ this." So it's interesting how the words can be used, and it just doesn't sound right when you say, "I'm gonna writ this." I could say, "I'm going to appeal this," and it is a form of appeal. So that's that's kind of proper. I'm going to writ. I'm going to writ this. That's what you'd say when it's in the writ category. I'm going to writ this. I didn't know. At the end of my trial, I said I'm going to appeal this, just because I didn't know. So now I'm more aware. The difference is there's a jury. So a writ is with a jury, is with a bench. The writ is with a bench, and the appeal is with a jury. And that's about the main difference that I understand. If I want to, if I accidentally go, whoops, I sent my writ to the Supreme Court, or even whoops, I sent my writ to the district court. There's a law that says that the district court is supposed to transfer that writ to the proper court. So I don't know why I'm getting chastised by Taylor Townsend saying, "Oh, this is improper." They just love to tell you what's improper. That's just their thing. But the way they interpret the law is they're happy to tell you what you're doing is improper, and not recognizing that there is remedy. That's the thing. With remedy, remedy's thrown out the window. Everything to seek a remedy that involves a more positive outcome is thrown out, and it's turned into more of monetizing. They try to monetize the remedy instead. But there's a law that says the courts will transfer the writ or the appeal. First they'll tell you if the appeal is... No, I don't even know. What will they do? Okay, let's just say that there is that law that they have to transfer. They don't have to convert, but they have to transfer. So they don't have to convert. Whoops. Convert, but they do have to transfer. They stopped conversions a while ago. So, I don't know if it's in... Gosh, I got things mixed up. What can be appealed? Yeah, that's the appeal handbook. We're in... I don't know what page. It's all the beginning, huh? Okay. So, the clerk of the trial, no. Only questions of law. Sentencing. Special ruling during the appeal. That's for motions. Supervisory circumstances. Time limits. The court will take of the application for the writ. Request for expedited consideration. Specific time in which the actions of the appellate court are sought. The most problems arise from filing that could be prevented. Counsel and local rules are essential. Defendant's conviction become final. Right to jury verdict. Courts of appeal will review only issues. Circumstantial evidence forms the basis of... Nope. So, motion, reconsider sentence, time delays. Man. So, there's a law that says that the transcript shall indicate subpoenas are omitted. 7 days of granting. Party not represented is not permitted to withdraw. Proper. Show a copy of the judgment's orders. Untimely briefs. Non-conforming. 40 minutes. Okay. Full opinions. Record of demonstrates that the evidence. Summaries. Panel. Frivolous. Stay of execution. Rules. Application and connection. 3 duplicates shall not be considered. Properly filed. Time extension. Intention. Let's see, application proceedings. When application, further proceedings may be stayed. Expedited. Judgment order. So there's information about how the writ needs to be transferred. And I know I wrote a note on it somewhere. Comments on rules. I don't think any of this is going to be it. Claims for relief. Comments. Okay. Alright, so it's not that pile. Internal rules. Filing facsimile. The clerk of each trial court deposits fax filing fees. Motion to dismiss. Sought separate statements. Change briefs. This is internal rules. You'd think that they would mention that you could switch over the proper jurisdiction. Alright. Faithful. Comply with local rules. Timely. Reply. Well, I know I took a note of it, but transfer of cases appealed to wrong court. There it is. Okay. So in revised statute, they do have to transfer. So under, look call it Louisiana revised statute 13.441, transfer of cases appealed to wrong court. Okay. So there's a law in the revised statutes. When an appeal is taken and perfected to an appellate court having no jurisdiction, the court which is taken may transfer it to the court having jurisdiction. So if I sent it to the second court, they could transfer it to the third court, and they don't dismiss it. Okay, they don't dismiss, or I guess it could be lateral or up and down. I submit to the second court, they'll move it to the third court. Or if I submit it to the Supreme Court, they'll move it to the District Court or something. Or if I move it to the Supreme Court, they'll move it to the third court. So there's that law, but they won't convert. And it sounds like they used to convert, but they won't convert anymore. So courts don't convert from appeal to writ. But they will transfer. They're happy to transfer. That's a part of their duties. And in this converting appeal to a writ, why is this up here like that? Alright, First Circuit. There's a Roba, and this is all civil case, but it's very similar. I got a writ, and they're talking about appeal converted to application for supervisory writ. Okay, so it's a supervisory writ, and that's what applies to me. So supervisory writs writs are non-jury, and that's what I am, and that's what the judge has a lot of experience with on the civil case is this supervisory writs, not so much appeal. When I told him how I'm going to appeal, he probably chuckled a little bit inside, thinking, yeah, go ahead, buddy, do that. Do your appeal. You were forced to do a bench trial, so you don't have that option, unlike other courts. So that's the writ, and there's several examples on this website. Because motion for appeal was filed 40 days. Yeah, mostly a timing issue. That was a problem. Had the motion for appeal been filed, they're talking 30 days, 30 days. Not converted to a supervisory writ. So they dismiss it because of the 30-day thing. So, and they don't convert. So there's the non-conversion issues. I guess they used to do conversions. Appeal dismissed and not converted to supervisory writ. So there's that. But they're happy to transfer, and that's just a part of their rules. You got 30 days. A writ application requires 3 copies. So I'm in a waiting period for the writ to be seen by the Third Circuit, and I don't know how long that's going to be. Days, weeks. How busy are they? So that's that information. So yeah, at the end of that trial, there was a conviction, and Robert mentioned other things that I did not write here. I was convicted on porn, which they love. That's like the first thing they love to bring up now. Porn. So porn, loud banging, big bags, cameras, asking cops their names, shaking door handles, rude to librarian. These are all criminal offenses now. They're converting general suspicion into criminal offenses. Yeah, asking for their name. Let's say going to the 3rd floor. Judge Owsley had to say something, so these are what made the conviction. These are what sold his conviction to the record. He's selling these items, and there's a couple more that Robert mentioned. These are his sale points, his selling points for the conviction on the record, so that anybody who wants to read this record can look back and see this. Let's see. Yeah, something about The Boston bomber too. I didn't even object to that. It seems so ludicrous, but apparently I'm the Boston bomber, even though we're not in Boston and there's no marathon. I I I was told that this is what they hear in the news. This is how well they keep up with the news. They're still dwelling on the Boston bomber. So that's a conviction, and then sentencing was eight like 894.1 using the sentencing guidelines. Let's see. Let me see if I can remember. We'll call it Louisiana Code of Criminal Procedure. The offender's conduct in the commission of an offense manifested deliberate cruelty to the victim. Nope, I don't think it's that. Why do I have a red dot on this? What's going on with that? The judge had to convince himself. Yeah, okay, I see. Alright, yeah. Alright, so I found the wrong law. Let's see, I wrote it somewhere. I don't write it in enough places. I got so many pieces of paper. Internal rules, okay. Appellate issues. So based on the conviction, based on what I'm being convicted for and sentenced for, it's very attractive to appeal this, because it just doesn't make any sense. I have a constitutional right to appeal, and I mean, okay, we'll go back to sentencing. I don't know the law. I don't, but I wrote it down in just like one or two places. 72 hours for judge to respond to notice of writ. They had a phone conference without me. No. 916? Oh. Judge Owsley's jurisdiction is limited by 916. Alright. Well, the sentencing is on some guidelines. And I don't know where those guidelines are. The reference. So, I guess it was 7. I know that is number 7. It was like my influence, and there are threats to librarians. Things got worse. And I know Robert mentioned more. I didn't promise to ask followers to stop their actions. Something like that. To ask followers to see, that's his fallacy, because he's thinking that if I ask people to do something, that they're gonna follow me. I mean, he thinks I'm leading a pack. Delay between verdict and the time between conviction conviction, 2 seconds pass, and we are in sentencing, where I'm told to please rise. It was only after like 2 seconds after he explained his conviction, after he said you're guilty, he waited a whole 2 seconds and then said please rise. So he never wants to ask anything to cover his own base. He just wants to plow through all options. And I have a criminal code 873 that's let's see, criminal code 873, let's say for Louisiana, part of the Code of Criminal Procedure, and I think that says you get 3 days. Delay between conviction and sentence. If I'm convicted of a felony, at least, and they say it's for a felony, so I don't understand, like, if a motion for a new trial or arrested. Yeah. Sentence shall not be opposed until at least 24 hours after the motion is overruled. So that was my fault. Oops. That was my fault that I didn't follow Criminal Code 873. And I had 2 seconds to make a motion for a new trial or in arrest of judgment. And I could file that orally, so I had 2 seconds, 2 to 3 seconds to verbally make a motion for a new trial, or even have maybe something in writing. And then I would have had 24 hours to get prepared. I would have gotten paperwork prepared. So I had Judge Owsley gave me about 2 to 3 seconds to make a motion for a new trial. That's all that he gave me, and I wasn't fast enough. This is something that a seasoned lawyer would be on top of easily. Easy seasons. Let's see. I guess it's this one. And I blew it. Whoops. I guess, yeah. This is all I'm writing on. There, and up and over. So that was 3 seconds. I got convicted and then sentenced, and there's a protection law. Okay, Judge Owsley was like the cops. Judge Owsley was plowing through because he is a cop. He should wear a blue robe. He was plowing through the aggressive laws, the prohibited stuff you're prohibited by, proactive laws. Okay, we'll just call them not protective laws. Protective laws. There's he was plowing through the offense laws. They love to plowing through the offense laws and ignoring the protective laws. Of course, I mean that's the cop's job. That's why you have to assert, you have to enforce, because they only learn the offensive laws from the cop to the city judge. When you get up to district judge, then they start recognizing the protective laws a little bit more. They don't like they don't get too familiar with the police policies as much, because police policies are all offensive laws, always to be offensive. They're the offense, um, and in between these offensive measures they take, you have protective laws. It goes back and forth. So um, I had my conviction, and then that was the offense. He was pushing, plowing through, and then I had my motion to retry the case. Motion for new trial. Motion for new trial would be defense, but it didn't apply any defense. I just kind of let the ball go through the defensive line, and then skipping that, we got right into conviction, into sentencing, which is offense again. And then after sentencing, I said I'm going to appeal this. But Judge Owsley knew I wasn't going to do too much from jail, so he won. That's a big win. So there's offense and defense, and as a defense, as a defendant, I'm scrambling to figure these choices out. They're not mapped out so well. So let's see. Now it's post conviction, and I the prosecutor rests until I make the next move. They're like, we scored the winning touchdown, and we don't need to do anything, except no, they need to follow through. The offense needs still, even after post conviction, even after post conviction, the offense still needs to follow through with the punishment. Not the correction. They don't care about the correction. They made clear that they don't want to look for a remedy. This isn't a remedy. The city courts are not remedies. They're punishments, and you have to find defense. The higher courts look for more remedies. This is not a remedy court. It's just to get the most out of their victims as possible. they're not. I mean, once again, Judge Owsley's jurisdiction is too limited for him to care about remedial measures. He's looking for uh, a gain. He's trying. He's got such limited jurisdiction that he's fighting to get more jurisdiction um, by imposing by trying to just to be on the offense as much as he is. He's fighting. He's fighting for more jurisdiction, more power as a. And I don't think no city judge has has ever gotten a jury, as far as I understand. I don't think any city judges are allowed to have juries. That's just that should be the way the magistrate is. So without that defense, that's a defense. A bench trial is an offensive measure. I don't know why people like bench trials. A jury trial is more of a defensive measure. You're using the community as to work in the defendant's favor. Although I guess people say juries work more in the prosecutor's favor. I don't know. I think I prefer to do a jury, especially when it comes to constitutional issues. So there's the offense, there's the defense, and in the I'm on the defensive level with submitting writs. So writs have to be submitted. The notice to writ is a 30-day time limit. They love to watch that down to the very hour of writs is 30 days. And let's see, I guess my writs will be composed mostly of the sentencing and the conviction. Trying to reverse, trying to get a new opinion on the conviction. What Judge Owsley felt was important, and that's the first one. We want to focus on a writ on the conviction, because if the conviction gets turned over, then you don't have to worry about sentencing, because sentencing would be mute. So the real focus is on conviction as a defense. So a writ is a defense. I guess prosecutors could use writs too, but because some judges out there don't rule in favor of the prosecutor, and it may seem unethical or illegal. So we're attacking the first. My writ must attack the conviction as a matter of law. So my writs, and I believe that's what's going on here. I got these writs right there. All these, notice to intent to apply, new trial, post verdict. Yeah. Just attacking the legal process that has gotten trampled over. Judge Owsley left little room for defense, and a small latitude for defense and a wide latitude for offense. Because all defense is all on the defendant's side. So all people who have to defend themselves, they need to know the law. and most don't really care to learn it, so they just accept the guilty plea and want to be, I don't know, considered to be in good standing with the local law enforcement, until the law enforcement gets real itchy fingers again, wanting to push boundaries further. So that's the writs, and it's being worked on. In the time that I was in jail, I got a ban from the library, permanent ban from the library. Oh, maybe I can make that bigger. So the work that I want to do cannot be done in the library anymore. Can't quite get it to line up. Because of my actions about watching hardcore porn for hours in the library, apparently, I get another ban, another lifetime ban in Natchitoches and Campty. So that makes things more difficult, but the heat is making things difficult too. I can't do as much outside during the midday, and I really need to seek out cooler temperatures. Now, yeah, people have said that if I had waited until the sentence was over and not have paid $1,500 to bail out 4 days earlier, then I wouldn't be bound by the bail. So I'm holding 4 days on standby for my jail time, and I'm held to a stricter standard for those 4 days by the bail conditions. So I must get a approval. I must get approval from the city, from Judge Owsley. Now, do I need to leave the state? Now, I'm trying to get him. Uh, I don't think he can sit in another trial. I think they're talking about getting an ad hoc judge for a retrial. Ad hoc judge for retrial. Ad hoc judge from the Supreme Court. And that'll take some time to speed things up. To have gotten out of jail, I turned down the ad hoc judge first and just settled on Judge Owsley deciding on my bail, and we fought for. I demanded an own recognizance bail, and all kinds of arguments were made. OR bonds, which then I wouldn't have had to pay $1,500 to the police station. Instead, Judge Owsley wanted it the full amount. So he made arguments that I'm literally living in my car. So that proves I have no ties to the community. You have to be like a public official to show you have ties to the community, I don't think even working at Walmart would cut it, since it's a franchise and you could transfer. So I argued for an OR bond, and I went back and forth. One of the most interesting arguments I ever heard was that upon um, the lawyer Philip mentions the GoFundMe. It said that he's getting all the money, not me. Philip mentioned the GoFundMe, and so Cloyd argued that GoFundMe is income. So that what is it at now? Let's have a look. Okay. Oh, I shrunk that, huh? Okay. I guess I get the link through Twitter. I should probably retweet. Let's see, retweet it. Let's see. It's not too far down. Right. There. Yep. This is the one. All right. So now click on it, and yeah. Let's see. There's this GoFundMe that was mentioned. Oops. All right. Let's see. All right. And so it was this GoFundMe is income, and I have to claim it as income, but it's all going to the lawyer, so it's quite interesting income. It's like you raise money to just pay for a service to for the as a part of the court process, and so now I have to claim it as like income, like I sold money, I sold service or goods, and people paid for a service or goods. But I mean, I would think that only one person should claim it as income, and that's my lawyer. My lawyer should claim it as income. Why would I claim GoFundMe as income? It's like, why should we both have to claim it as income? There must be something that would, something in the tax code that would make it make a make a difference that would divide and cause a difference in the status of how that money is really, because he can blow that money on a new car, and I can't. That my money, this money is already decided upon. It's already going to him, and it may not even be enough. So where are we at here? So who else donated to the GoFundMe? Let's see. How does the church come to the determination that there is income? Yeah. Does the church claim income? The attorney should claim as income. Yeah, because I don't know if two people, like, we're not married, and it's money it's never, it's money that never touches my hands, right? I don't even know how it works. It goes into Robert Parker's hands. Does that money go into whose hands? Like, does it go into my hands and then I turn it over to the lawyer? I mean, it has to go into somebody's hands first to be decided upon. But this money is like, it's not just money that's loose income. It's already been, and it's called a fundraiser. I mean, isn't this fundraiser is near you? So how do you? I mean, they're clearly calling it a fundraiser, but my prosecutor called it income. Um, my lawyer was a little surprised by the argument. Who wouldn't be? So it's an income, like, or a fundraiser. It's income for my lawyer, at least. It's a fundraiser for me, and it's income for my lawyer. I would say that there's there's got to be uh, a noticeable difference in the tax code. And of course, my prosecutor, Benjamin, he's not a tax expert. He just makes his crazy arguments. So he works on trying to trying to stir the pot, and he just does that to try to get the worst out of people. It's um, I claim it as income and then get to claim the expense. I claim this GoFundMe as an expense. Yeah, it's definitely an expense. All of it, whatever amount. It could be 10,000. It could be 100,000. It really shouldn't. It really shouldn't be just income alone. I would need to claim it as, yeah, something that where it's an expense in some way that is not something that's expendable. It's an expense. It's not expendable income. It's not it's not expendable income. It's expense. It's more expense income. Expendable income? I think not. It's fundraiser income. How do you file taxes on that? All right, on my end, fundraiser taxes, because how do I can't just that it'll bring me, it'll easily, this fundraiser will easily bring me above um the easily bring me above poverty line for sure. This I mean this fundraiser by itself has the potential of putting me in above. It has by its own goals has the potential of putting me uh, above the above above the poverty line. One little fundraiser can put you above the poverty line, and you have to pay taxes. Are made to personal GoFundMe fundraiser. Are generally considered to be personal gifts, which for the most part are not taxed as income. It's a gift, yeah, because I've talked to other inmates, and uh, I talked to other inmates who have needed to talk to their family and friends to raise money for their own issues, to get lawyers to try to clear up their names. It's generally considered to be personal gifts. So, well, yes, ask my lawyer these fundraiser versus gift versus income. Well, my lawyer got tripped up. Okay, I got tripped up. I had nothing to say. He was tripped up by this income. Uh, and it really it didn't quite matter because Judge Owsley had his decision already made anyway. He's got limited this jurisdiction, so he's got limited resources. He doesn't need to take in all the factors of our. He doesn't need to look beyond the code of criminal procedure by itself, and especially the prosecutor doesn't either. You'll never see the prosecutor mention civil rights. That's not their. That's not. It's not a part of their job. Civil rights are not their job. Any gifts over 10,000 is taxable as not as income though. So that's what's and that was argued for my bail. I couldn't get an OR bond. I had 2 bails for this case now. 2 bails for this case. The first bail number 1, the first one, I paid $220 to Brandon Berryman, and then that got me out of jail the first time, and then it was good until the conviction, and then which erased at conviction. So the 220 was my fee to him to hold, I think, about 1,500 or something. So, and then bail number 2 was me paying 1,500 and bailing out myself. Now I had to do that from the outside. All right, I had to bail myself out from the outside. So it took other people to do that, and it's a process I don't understand. Robert Parker, aka something pig something. Let me look at his website. There's only my information on here. So this is my bail, and I'm held to standards. I can't leave the state. I agreed to that by signing. So I agreed to this bondsman. I'm the bondsman now. I'm the surety bondsman. But I can't leave the state. That's a big one, not being able to leave the state. So I want to request that. I want to request to leave the state because it's not clear to me when the next court hearing is that I have to attend. Because it doesn't even sound like there's Judge Owsley said that one of us needs to show up at city court over my $411 fine. So one of us. And to save money, it'd probably be better that I go by July 7th, 18th, because lawyer Phillip would have to drive from Shreveport and back just to show up for that fine hearing. But the thing is, I show up by myself, and I put myself at risk of this contempt of court hearing, direct contempt of court hearing. That's Judge Owsley, contempt of court hearing that Judge Owsley says that is in limbo right now because of my voice recorder. Judge Owsley has my voice recorder. See, that's the thing. I think he was in a rush to arrest me so that he could have me searched for my voice recorder. I think he did that. I think he rushed through it. There was only 2 to 3 seconds between conviction and sentencing. I think he was just so giddy to get to my voice recorder. I think he had strong suspicions I was carrying a voice recorder. And if I asserted my right my right to a hearing, I have a right to an appeal. I have a right to an appeal, but I needed also. I was a little late though. It's like you got to do it after conviction, not after. You got to do it after conviction, not after sentencing. I said I'm gonna appeal this after sentencing, and he told me to stand up for my sentencing, and I needed to assert. I needed to stay seated down and say, I'm appealing this. I demand a retrial. I make a motion for a retrial. And he says, He says, you're denied that. As a part of the law, I have 24 hours to prepare for the sentencing. I should have been sentenced the next day, and I should not have been placed in handcuffs right away and searched and had my voice recorder taken from me right there on the spot for them to then search the voice recorder and then illegally finds a previous hearing recorded. So this contempt of court hearing, this contempt of court that Owsley is holding in limbo, once again, as a part of their whole process, is illegal, and contempt of court was what was like this. I would want to do motion to suppress evidence. Motion to suppress evidence. Well, actually, no. I guess first thing I would want to do is motion for discovery of evidence over the evidence that he wants to use against me for my contempt of court, and then I want to suppress it. I want to make sure that I know that we're clear, we're on the same page. Motion for discovery of evidence for my contempt of court, and then do a motion to suppress evidence saying that I have a right to a new trial, a right to a new trial, a right to appeal, and um, bull rushing through through from bull rushing from bull rushing from conviction to sentence uh, within 3 seconds was I think a due process issue. It's a due process 14th Amendment. It's a 14th Amendment due process issue. I should not have I should not have even gone to jail. I could have gotten some paperwork to appeal, get the writ, whatever. In 24 hours, I could have had that done. I should have not gone to jail, and I should not have had my voice recorder taken from me. It was another Perry Mason moment, another Perry Mason moment in in Judge Owsley's courtroom to bull rush between, and you don't really you don't see that in the minutes. That's the thing. There's no time stamps on the minutes. You won't see that on the record. It'll just show that the order was done. The appeals court will have no idea how much time actually elapsed between the conviction and the sentence. All right, he convicted me as not guilty. Instantly, it was please rise for your sentence. Instantly, there was no pause of 30. There was just an instant turnover. And when you're reading that on paper, you really don't know. You don't. You, um, I don't know if that needs to be explained as part of an argument or what. For an appeal or a writ. But that was another Perry Mason moment in my trial, on top of other ones like Judge Owsley telling me that my that the thumb drive that I gave uh, was no that was not at the clerk's office anymore. I turned it in like 3.5 weeks before, and about 3 weeks passed before we had our fifth hearing, where we did discuss the thumb drive, and for some reason Judge Owsley didn't think to mention that the clerks no longer have the thumb drive, and this was within days. Hearing number 5 was within just a couple of days before my trial. Hearing number 5 was over getting a lawyer, which I was denied, and we did talk about the thumb drive. I was like, I turned in this thumb drive. He's like, oh, you did, huh? And then I was like, yeah, we're gonna try to figure out how to get it to work on a computer. And he's like, oh, I don't want to talk about that. He didn't want to discuss it. But then we get to trial, and he's happy, he's giddy to talk about how the clerks never kept the thumb drive. But he wanted to wait until trial to tell me that, instead of telling me that at hearing number 5. Both hearing and trial or within days of each other, and I turned the thumb drive in weeks in advance. So it was a game that he played. He played the same game a prosecutor would play, but in the judge's role. City judge. Typical scummy city judges. What else going on here? So, I don't know. Has anybody donated anything? What are comments? Alright. Let's see. Thank you to Anonymous. Thank you. Recent and top. First. Oh, okay. Recent, top, and first. Yeah, my lawyer is going to take every penny plus even more, I believe. I want to keep the work of my lawyer as minimal as possible, but I mean, everything's got to go through him. So I want to request. I want to request to be able to leave the states, but I want to recuse Judge Owsley first, and then ask from the what did they say that was? Oh, I got it somewhere here. The ad hoc judge. Yeah, there it is. The ad hoc judge. I want to ask, or I guess it wouldn't hurt if I asked Judge Owsley. He denies it. Whatever. He's a city judge. I expect him to deny it, and I'll still have the option of asking the ad hoc judge about leaving the state to go to Wisconsin. So I was really interested in going to Wisconsin in the summertime. Let's see. Phillips, don't play with our money. Yeah, it's your money, guys. I'm not really. I don't think I'll ever even get to smell that money. it's it's the donation money. He's getting money from multiple people. It's not like I'm a big businessman and I'm cutting him a check off of my own savings. It's this all money is coming from you guys. You guys, the same guys who convinced Judge Owsley to sentence me for 30 days. You've turned around and invested in a lawyer to now help try to reverse the conviction. Reverse the conviction first, and if that doesn't work, reverse the sentence. All right. To just even drop the 30-day sentence, to drop the $411 fine. That would be nice. So there's two approaches there, two levels to approach with this Third Circuit Appeals Court for my writ. The supervisory writ is done at the appeals court. Something's already out on YouTube. Yeah, what's Robert's channel called again? Something pig. I got it written down. Pig trader Robert Parker. So let's pull this up. Okay, and then I can pull. Okay, that's the campaign. Oh, I gotta go to YouTube. Pig trader Robert Parker. Okay, he's a fast growing channel. Let's see, there it is. Alright, and then I can show it. Let's see, let's make a window. And, okay. Yeah. So he started a channel. He's a very helpful person. He's very knowledgeable in his ways. I mean, it'd be very interesting to just see if there's anything that we don't know, how he convinced the police to let me bond myself just by paying the full amount rather than find a bondsman. Bondsmen don't answer the calls anyway. So if you have friends or family outside and you can pay the full amount, a lot of guys can't. Some guys are stuck in jail with $500,000 bonds. They don't have that. You got to prepare though. You really got to prepare for this stuff. You can't always rely on GoFundMe. You can't rely on the family or friends. So, but I mean, it's yeah. Cities can really surprise you. They bull rush you and surprise you, and that starts at the police level, and then it just works up from there. Bull rushing you through the offensive laws on the police level, and then on the city court level. I want to, this is an exploratory um, issue. I want to find out, where does the bull rushing stop? Okay, at what point does bull rushing stop? There is a point. U.S. Supreme Court would stop the bull rushing. They would definitely want to be more considerate of our protective laws. They want to recognize our protective laws, whereas on the lower level courts they don't care about protective laws. Was the cell air conditioned? Lackluster picked up on your story. Yeah, I've talked to Lackluster a little bit. Well, not recently though. Cell air conditioned. Yeah, the cells are air conditioned. That's a benefit to have air conditioned cells. That would make waiting for any court dates a lot easier to deal with. Because sitting in my car in 90, 100-degree weather coming up is not looking good for me. Cloyd emails to bondsman. Hey, yeah, I wanted to share that. Since I no longer need to keep our email secrets, I wanted to share. This is our secret email that we were sharing. My prosecutor secret email. So it's no longer something I need to use. It's something he'll probably want to just turn off. Let's see. There's no justice in Louisiana. Yeah, where do you find this justice? I've spent more time in jail in Louisiana than the other 4 states combined now. Jail food is similar to college food. I owe them a lot more than food. Yeah, when do I get to start the lawsuit? This is really being prolonged. Yeah, I see Trish sent an email about uh, um, Louisiana. I have returned. Are there 2 people total in here yet? Yeah, it's 200. I don't see a time on the website, so I guess I need to go to OBS. How long have I been on? 1 hour, 18 minutes. I'm having difficulty sleeping. I want to sleep, but I'm not tired enough. Owsley under question. Yeah, Owsley's done so much. Unearned income. Yeah, I didn't earn this income. I just kind of sat in jail, and money started. How do you earn income from jail just sitting in jail? It's like that would be an argument to make. You, Prosecutor Benjamin says that I made income from GoFundMe, but I was sitting in jail. Okay, how do you call that income? I was not working. I didn't even make the GoFundMe. It was made while I was sitting in jail, and I had no communication with anybody. So how do you call that income? That's the argument to make. That's something that my lawyer Phil, didn't really think of, and that would have been interesting. He stuck with this indigency argument, which wasn't really convincing. And we're getting minutes on this last hearing, but it's like you're calling GoFundMe income. I'm sitting there in court in inmate clothing. They know I've been sitting in jail for the past few weeks, and and they know that I've been getting this. They know that this GoFundMe started, and they still can turn around and call it income. Like I figured out a way how to make money off of sitting in jail, like on a regular basis. Like why am I? If I could make that kind of money, all right, 3 weeks, two to 3 weeks in jail, make $10,000. Is that how income works? I just need to sit in jail, uh, and make $10,000 every 3 weeks sitting in jail. How long does that last as a viable source of income? It's not. It's a one-time donation. Yeah. Mike Stevens is blocked on Cop channel. I don't know how to get him back. I already pulled him from moderator status, all statuses. Mike Stevens is probably the only blocked account on this channel. I don't know of any others. I'd have to. Maybe I can look. I'm in a better situation here for researching. And I'm not at the library. All right. Let's see. You are under extreme duress with wrongful. Yeah, this is very duressful. I really would be going north and experiencing the cooler weather. Wisconsin's looking great for weather. It's looking terrible here. Pull up your email and read the heading of the email I sent you. Also, that website can steal money back, so until anything is in one's hands, it's a promise. It's just a promise. Can't also be detective. Okay. Yeah, so I guess I'll stop here. I really don't have a theme for writing, for talking about much. Just rambling on, looking at the various documents, trying to catch up for the past few weeks now, and it's a process. So yeah, I'm just gonna